Good evening, good afternoon, good morning, those who are listening to this podcast and to this video recording. I'm Eszter Kismödi, Chief Executive of Sexual and Reproductive Health Matters. And I'm here today in Geneva with James Yap, who is the Acting Director of the International Human Rights Program at the University of Toronto Faculty of Law. You are being here, James, today. Hello.
Hi, thanks, Eszter, for having us.
And I'm also here with Anjli, Parrin, who is the director of the Global Human Rights Clinic at the University of Chicago Law School and joining us from Kenya. Hi, Anjli.
Hi, Eszter. Thanks for having us on this, and thanks for allowing us to talk about this issue.
We are very pleased to have this conversation with you because it's you brought a report to the CEDAW Committee, a submission to the United Nations Committee on Elimination of Discrimination against Women on the occasion of the committee's review of Canada's 10th report prepared by your programs and endorsed by several organizations around the world. And it is connected to the sexual and reproductive health and rights of women in Gaza, and connected the state obligations of Canada in relation to CEDAW. It is a very unique report. When I read it, I thought I need to have this conversation with you because you are taking such an important, unique angle that so many people would like to address, and actually you have a submission, so we need to hear about it. Can you please, James, give us a quick summary of the report and its nature?
Thanks, Eszter. So we're here in Geneva for a meeting of a UN committee on women's rights called the Committee on the Elimination of Discrimination Against Women, or CEDAW Committee for short, as you said. So among other things, the CEDAW Committee periodically reviews the women's rights performance of states every 4 to 5 years on a rotating basis. And so right now, the committee is doing its periodic review of Canada. So the committee reviews a state's performance on women's rights through the lens of the various rights set out in a treaty called the Convention on the Elimination of Discrimination Against Women. As part of this evaluation process, it receives submissions from civil society organizations about the women's rights record of the country being reviewed. And so we've submitted a report that's been endorsed by almost 50 organizations, as you said, on the contribution of Canada's export of arms to Israel to violations of women's rights to maternal health care in Gaza. Now, like probably most Western countries at this point, Canada has largely stopped issuing permits for the export of arms directly to Israel. However, indirect arms exports to Israel continue largely unabated through the US, which, of course, is Israel's largest global arms supplier. Under Canadian law, most arms exports to the US do not require an individual permit as they would to other countries, and so arms exports to Israel through the US can and do continue largely unimpeded. So, for example, in August, the US government announced an intended transaction in which it planned to purchase 50,000 water shells from a Canadian company and then turn right around and flip them to Israel. And under Canadian law, there's nothing to stop this, as there are zero export controls for the transfer of such arms to the US. And the act of stopping direct arms exports to Israel, of course, is merely performative if those arms can be and are being simply rerouted through the US.
So, Anjli, can you please tell us a little bit that how is it connected to CEDAW? Like, how is it connected to women's rights, and what kind of human rights violations did you document? And can you also please tell us about your methodology, because it's always very difficult to have an evidence-based account of human rights violations in a short period of time. So how is it connected to CEDAW and women's rights?
So let me start with the methodology first. I think one of the challenges, we faced a number of challenges in trying to document violations of women's rights, and we focused particularly on maternal, obstetric, and reproductive care, and its impact as a result of the conflict that's ongoing in Gaza. A couple of the challenges. So the first challenge is our broader research is a collaboration between legal teams and lawyers and medical teams and doctors. And anytime you're trying to carry out interdisciplinary work or interdisciplinary research, that's going to be a challenge. As a lawyer, it's incredibly important to me to try to find out what caused a particular human rights violation, because I need to be able to connect a violation to a specific actor and a specific set of harms. As a doctor, you're often loath to say that something is caused by something. You might want to say it's consistent with something. And so that's been a sort of ongoing challenge of how do we do work that's quick, that's going to impact the conflict, that might try to prevent some of the violations that we're seeing, while also keeping the methodological rigor and ensuring that it meets the criteria for peer-reviewed medical journals. And so, of course, the way to do this is to do both. So we have an IRB and we're working on the medical side, but then we're also pushing forward with human rights advocacy and legal advocacy. For this specific report, we relied on open source intelligence investigations. So we did a very thorough review of all of the publicly available information about maternal, reproductive, and obstetric care. And of course, one of the things that's unique about this conflict is it's very well documented. There's lots and lots of information. It's in the front page of the news every day. The second thing we did is interviews with healthcare workers on the ground who were witnessing and seeing a lot of the violations. And finally, we compared that also to analysis of photos of other forms of evidence that doctors were collecting while they were in Gaza. And so we put all of this together to find our report. In terms of how this is related to...
Can I ask a question? Because James said yesterday that you also looked at hospitals and counted on hospitals that on the 7th of October and then compared. Can you say also about that? Because I think it was also a very important methodological aspect of your report.
Yeah, we did a survey of all of the hospitals in Gaza that were providing maternal, reproductive, and obstetric care prior to October 7th, and what happened to them. How were they affected? How were they attacked? Since, almost every hospital in Gaza has been in some way attacked through this conflict. And the World Health Organization has been keeping really strong statistics about what's happened to all of the hospitals. Since then, there's also been some efforts by doctors and by humanitarians to set up field hospitals, so ad hoc hospitals to respond to maternal care needs during the conflict. So we also looked at how some of the new field hospitals were operating, the shortages that they might have been facing, the lack of humanitarian aid that they were experiencing, and analyzed those using publicly available information, reports from the UN, reports from medical organizations and doctors, and then, of course, a set of key interviews with people who were there on the ground.
And what kind of violations you found?
So we found a range of violations. One of the things that was most alarming is that we basically found that the conflict has affected every stage of a woman's journey to try to get pregnant, from trying to get pregnant through being pregnant, through giving birth and postpartum. At each of these stages, they face enormous challenges due to violence, human rights violations that are caused by hostilities and direct attacks by Israeli forces. So even before we talk about the kind of maternal violations, we found that, there's more than 690,000 menstruating women and adolescent girls in Gaza. And it has made the availability of menstrual products very scarce or expensive. It's really hard to have clean private toilet facilities. And thus you have a problem of public health and of hygiene. When it comes to trying to get pregnant, we at least documented one incident of an IVF center that was bombed, leading to the destruction of 5,000 embryos, sperm, and gametes. when women are pregnant, they face enormous challenges. Malnutrition is very high, which means that women are frequently not getting the level of nutrition that they need to have a healthy pregnancy. It's very hard to get access to pregnancy vitamins, for example. And where they have complications, getting access to a hospital is very, very difficult. When it comes to giving birth, we had anecdotal reports of doctors who said that, women were getting cesarean sections, but then having to leave the hospital in 2 hours because there's just not enough beds. Lots of examples of postpartum bleeding and of complications due to pregnancy. So at every stage, you have these issues. And of course, with newborns, that, a lot of women are not producing the amount of breast milk that they would need. And so it's very hard to get clean water to have baby formula, for example. And so we see these compounding violations, which traditionally in international law have been ignored as it comes to women's rights violations. There's often a very strong focus on conflict-related sexual violence, but we find that these broader violations and attack on the healthcare system are incredibly devastating.
And I also can imagine that many women don't want to get pregnant in this situation, or may not wish to keep a pregnancy. So equally, access to contraception or abortion may be also challenging. So I also wanted to ask that it very often comes that those who are not necessarily involved in understanding what is the nature of a human rights violation, what constitutes to be a war crime, what is the difference? So what is the difference? Just can you just a little bit explain what is the difference between war itself is not illegal by international law, or some certain aspects of it, yes, but what is the difference that war comes with casualties, and between that there are impermissible human rights violation and war crimes? What is the difference between the two?
So legally speaking, conflict and war is governed by an area of law that's known as international humanitarian law. Sometimes it's called the laws of armed conflict. Now, one thing that should be stressed, obligations related to human rights do not cease in periods of armed conflict. Thus, we have this report, which we're submitting to the CEDAW Committee, which is a human rights body. It's a body that deals with women's rights, and women's rights do not stop simply because you're in conflict. But of course, when you have international humanitarian law that applies, often that's going to be the more specific set of law. And where you have a conflict between these two areas of law, you're going to look to the most specific. The laws of war were created to ensure that the conduct of hostilities are humane, that there are things that are permissible to do, but equally in times of war, there are things that you cannot do. And it's really governed by these three fundamental principles. The first, which is a principle of distinction. The parties to a conflict, those engaging in war, need to distinguish between who is a civilian and therefore not targetable, and who is a combatant, and between an object that is a civilian object and a military object. Therefore, it's entirely permissible to target military objectives. If you're an army, you can target another army, but you cannot target civilians. Of course, in practice, there might be civilians next to military targets. It might not be possible to precisely target every combatant, and of course, especially in contexts where you have urban settlements, you might have civilians and combatants together. In that case, you need to think about the principle of proportionality and the principle of military necessity. So is what I'm doing, is my military objective necessary to achieving its aims, and is it proportional? Is if I'm targeting one member of an armed group or one general, and I'm going to kill dozens of civilians as a result of that targeting of one person, perhaps that's not proportional. That's a case-by-case analysis. So every time you have an instance where you're about to act, you need to think about, is that action actually proportional, or am I causing unnecessary suffering, superfluous injury? Now, that's the general status. There are also a set of individuals and objects that receive special higher protection under international humanitarian law. A key one is hospitals, medical facilities, medical transport, so ambulances, and healthcare workers receive special protection under international humanitarian law. And so there's a higher standard that's involved in any potential targeting of a hospital, and the exceptions are really rather limited. Same thing would go for humanitarian workers. And of course, there is an obligation even in times of war to ensure uninterrupted humanitarian aid and to ensure that the civilian population continues to be looked after.
Thank you so much. James, you mentioned that your introduction, the nature of the report, how Canada comes to this issue. But can you please a little bit further explain that what did you actually present to the committee? Usually we get used to that when we look at state obligations under treaties, then it's a state who violates human rights in the state territory. And in this case, we are talking about Canada in relation to women who live in Gaza. So can you just a little bit more further explain that what did you present exactly to the committee?
Okay. Yeah, so you're absolutely right that usually when we talk about the international human rights obligations of states, we're usually talking about the obligations of states within their own territory with respect to people within their own territory. However, that is actually an exception to international law more generally, which is primarily concerned with the actions of states outside their borders. In fact, one of the foundational principles of international law is the principle of sovereignty, which protects the sovereign will of states within their own borders. And so, if anything, I would argue that it is more in line with international law to look at the extraterritorial obligations of states. And what's more, and especially in today's globalized world, a state's conduct may actually have impacts both inside and outside its own territory. So an assessment that only looks at the human rights impacts of a state's conduct within its own territory is ignoring a very important aspect of a state's conduct and presenting only an incomplete picture. And then on the other hand, there are many human rights problems that at first glance may appear very localized, but are in fact caused at their root by global institutions of power that can link many different injustices around the world that otherwise appear strictly local and unconnected to each other. So for example, the crisis in Gaza goes far beyond the immediately implicated actors. And although it's important to criticize those actors, such as Israel, you can't fully address the problem without also looking behind the curtain and targeting the accountability of some of the global actors, notably the US, that provide Israel with its impunity. And that's what we're trying to do here, is make those connections to the global institutions of power. Canada's not bombing hospitals directly, it's true, but it's very much implicated in the global networks of power that are responsible for perpetuating this crisis.
And James, just to understand, because this situation occurred in Gaza, but in many other war situations and armed conflict as well, just to understand, using the example of Canada, do you have to have specific laws within Canada that help to hold the state accountable, or it is under international law, or both of them? So is it actually Canadian law that applies in this situation, and is it more helpful that the state of Canada has certain laws that actually applies parallel with international human rights law as well?
Yeah, so for sure. So the CEDAW Committee looks at a state's obligations under international law. And in many countries around the world, that is enough. It's enough to say that a state's conduct is contrary to international law. In Canada, like a lot of countries, the US and the UK, for example, you need a little bit more than that. You need some kind of either domestic legislation or domestic legal principle that incorporates the international law into domestic law. In Canada, particularly with respect to the international law applicable here, and there's a wide range of international law rules, including the law of armed conflict, the laws of war that Anjli just spoke about, as well as international human rights law. We're talking specifically about women's rights, which apply in times of peace and war. So there's a number of different mechanisms that in Canada we use to argue that international law has some kind of domestic legal effect, but we can also use our domestic constitutional laws, which also talk about things like women's rights and the right to life, to try and import some of those arguments from international law. And Canada's constitutional order, like the constitutions of many states around the world, judges, when interpreting it, they try to harmonize their interpretation of Canadian constitutional rights with the interpretation of the equivalent rights in constitutions around the world, as well as under international law. And in fact, a lot of Canada's constitutional rights are directly inspired by and drawn from international legal principles, such as the Universal Declaration of Human Rights.
So the NGO briefing happened yesterday when you presented your report with the CEDAW Committee, and today there was the actual discussion of the committee. Many NGOs are submitting reports on many subjects, indigenous population or actual violation that happens in Canada and within the state as well. And sometimes the committees don't even pick the questions to discuss particular issues or reports. What happened at the briefing and what happened today? Was your report picked up? Was the question discussed in relation to your report?
Yeah, we think it went very well. The question was definitely picked up. We think the committee members were definitely onto the issue. They pressed the government of Canada with some hard questions. And so we're happy with that. And we're hopeful that the committee will come out with some strong conclusions and recommendations for Canada in 2 or 3 weeks' time when their concluding observations are released. On the other hand, we were very disappointed, if not surprised, by the answers that came from Canada, which largely tried to evade the question by giving answers that didn't quite answer the question directly.
So as you mentioned, the concluding observations and recommendations are coming out around 3 weeks' time. And we don't know at this point what those recommendations might be, how far they may go. Let's suppose that maybe there are recommendations, and we often invest so much into this report documentation, but the real work is really starting. That if there is a recommendation, then how do you actually use your recommendations to hold and negotiate the implementation of these recommendations? So what kind of work is happening if, let's suppose, the concluding observations give recommendations with regard to your report?
Yeah, and so it's hard to speculate on that without having seen the concluding observations first, but generally it's quite true that there's a lot of skepticism towards these UN treaty processes and international legal processes, sort of on the grounds that, oh, international law, it's not binding, there's no one to enforce it, it doesn't really matter. But I would argue that although all those arguments are true, it isn't binding. It does matter. You can tell by the way these countries show up at these hearings and really do their best to defend against a lot of the allegations that are being made against them. You can tell by the way countries like Israel are responding when South Africa brings a case about genocide against Israel to the International Court of Justice. If you look at their reactions, they're not acting as if it doesn't matter, right? Because the truth is, international law, although it has no enforcement mechanisms, it does have a way of percolating into domestic law eventually. And so we hope that participating in these processes and engaging these processes is just the first step of doing that. Ultimately, Canada is the one that needs to take a leading role in upholding international law and show that it is a nation that upholds the rule of law. And we need to, when the concluding observations come out, we need to take on the task of pushing domestically, not just in courts, which we're doing, but also in the public political engagement process to try and ensure that our government takes the lead in upholding international law.
Yeah, and actually the journal in the past 30 years really have been documenting the precedents and the actual stating of human rights violations. In the past 30 years, there were cases in relation to maternal mortality and health system failures, how health system failures in relation to maternal mortality, for example, the Ellen case in Brazil, and then documenting that what kind of negotiations happened after, and actually some states take it very seriously using this international angle, or criminalization and imprisonment of related to the restrictive abortion laws in Nepal, the European Court of Human Rights Committee in relation to restrictive abortion laws and criminalization in Ireland and Poland. So we have the history, a very rich history, when actually we can see how international human rights law can an actual impact on people's life. And maybe if it's not the impact directly right now on the women who are suffering, but maybe it applies in other war situations for prevention purposes and not allowing certain things to happen. Congratulations for your report, and have a safe flight back to Canada. And I really appreciate this conversation, and I hope we can follow up what happens after this. Thank you so much.
Thanks so much, Eszter.
Thanks, Eszter. Can I say one thing just related to that? I think this point about the role of your journal in advancing change is so important, because you can get a really strong legal judgment and you can get a really strong statement from the CEDAW Committee. But ultimately, what really matters and what's going to change the experience of people day to day is its implementation. And that requires popular change, that requires change from doctors and experts and everybody involved in implementing and upholding those human rights. And so I think having these conversations in a journal space, talking to experts across disciplines about the real broad set of harms to sexual and reproductive rights, especially in times of conflict, is just so critical and so crucial. And that's ultimately what will move the needle to improving the situation and changing things for the better.
Absolutely, and it may even help the negotiations of those who are negotiating the ceasefire or certain acts to happen or not happen, or the arms supplies or whatever on a daily basis as well. Thank you again. Thank you very much. And I hope to hear from you very soon. Thank you. Bye.
Thanks for having us.
Thanks so much, Eszter. Talk soon.